Boom. Hey, folks, how's everyone doing? I'm in a lot of pain, so this is going to be a short stream. I figure I need to spend some time in a bathtub probably because I need to try to soak some of this out. Also, I'm a little late because a friend of mine got called to the bench. Now, called to the bar is becoming a lawyer. Called to the bench is becoming a judge. So she's becoming a judge. And that is amazing because she will be amazing at it. She will be awesome. And it's hard to think of a better choice. It's much deserved. And quite frankly, was probably deserved some time ago. So we have 7.5 hours of trial today. And we're not going to go over 7.5 hours of trial because most of it, quite frankly, was devoid of fireworks. Most of it. So we're going to, and I set up a goal. It's a kind of fake goal because I'll probably do it anyway. But the goal is for bath bombs because I'm going to, after this, I'm going to soak in the tub and hope that my back will stop trying to murder me. But let's jump right in here. Let's see. We're just gonna maximize this. We're going to, nope, this is, we'll do it this way. So here we go. I think. There we go. And boom. So, do I have a local YMCA or community pool with a hot tub? Yes. I don't have any CBD bath bombs. That sounds like a great plan. I don't have a heating pad, but I do have a heating like thing of sand. I might try that. So, am I going to OnlyFans that tub action? No, we are not doing hot tub streams. The tub is going to be Runkle time. That's about it. So, what is it? Kristen, I did that yesterday. I talked about the asshole comment. I don't think it's going to be a big deal, but I know a lot of people want it to be. But at the end of the day, I think it's going to be just it's going to be a wet firecracker. And indeed, we don't actually hear anything about it today. We don't actually see we don't actually see anything about it at the moment. So, all right, let's have a look here. Let's see how they start off. So, we will go to the first thing that happens is this. So this is Maureen Hartnett. This is the tail end of her. Now, if you saw yesterday they were landing some good solid punches on her. Not literally, of course, but they were making some serious they were making some serious sorts of headway. Today, very little happens with respect to her. So we're going to largely skip her. I don't think there's a whole lot to say about her. She just sort of testifies as to that. Now, after her, we have Irini Scortibello, Dr. Irini Scortibello. So, Dr. Irini Scortibello is she is the medical examiner. And so the reason why she's on is to actually provide some evidence that we haven't heard yet that basically says that John O'Keefe is in fact dead and how he's dead, because that matters. Now, I've been asked to explain my give, send, go. So we're going to take a short break to explain that because, okay. Now, I am going to say I kind of screwed up on the give, send, go, and I'm going to explain how. So, I'll drop the link in the chat. Here is the link in the chat. So, this is the give, send, go. This is to fund me going to the Supreme Court. This is now, I am already $12,000 deep in the Give, Send, Go, or in the Supreme Court thing. Which, so $4,000 plus $8,000, $12,000 deep. And that's before I have leave. This is in the process of applying for leave, and there's going to be more costs applying for leave. So I was like, I better set up a Give, Send, Go or some sort of fundraiser because I would like to stay married. And explaining to your wife that you are $12,000 deep on like a cause like this is it's a great way to let's say challenge your relationship. So so I needed to set up some fundraising, and here's the mistake I made. The mistake I made is that I didn't realize the level of support that I had because I set this up like 2 days ago. And you'll notice, if you can see in the corner, that I set my goal at $40,000 and I have raised $44,500. Now, I actually figured it would take some time. So I don't actually have a final estimate. And so there's two problems on this. Problem number one is that if I don't get leave, if the Supreme Court shuts me down, then $40,000 is too much money. And I will have to figure out a way to give it back to the community. If I do get leave, then I will... do I have to pay taxes on these funds? I think so. If I do get leave, then it might not be enough money. I was actually figuring that I could, increment the amount as we go. So I expected that this would be a slow process of fundraising, not that it would be like explosive and like a massive thing. So I am like, I don't know what to do here. So I really hope I get leave. And if I get leave, this will be tremendous for all of that. So if I don't get leave and I've got a bunch of extra money, then I'm going to have to ask people, hey, what do you want me to do with this? Do you want me to use this to fund cases to run for other people? Do you want me to donate it to the gun orgs? Do you want me to donate it to the stallery? What do you want me to do with it? Because I don't think it's right, and I don't think people would be happy with me going, great, I didn't get leave, I'm going to put all this in my pocket. I don't think that's really the way to go. So I don't really know if Give, Send, Go allows for like refunds or whatever else. But if I don't get leave, I will figure that out. If I do get leave, I'm hoping that the 40,000 is enough money and we'll cover everything. If it's not, then I'll come back and, be like, okay, I need more help. Now, this is a good question. What does get leave mean? So when you want to bring a case to the Supreme Court, you don't just get to go to the Supreme Court because you want to, unless you fall into certain categories. If it's a criminal file and this is an and, if the Court of Appeal has a split decision on it, then you can just apply to the Supreme Court as of right, which means that the Supreme Court must hear it. But otherwise, you have to actually get permission. You have to ask the Supreme Court, hey, Supreme Court, this is a case I really think you should hear, and you should give me permission to properly apply and to properly run it. So first, before you just go to the Supreme Court, you have to apply for leave. And that means that you have to ask the Supreme Court for permission. The test for that is that it has to be a matter of public importance. So public importance means that it affects more than just yourself. It has to be something that affects a lot of people. And ideally, it has to be something that affects, sort of legal principles. Because the Supreme Court, believe it or not, the Supreme Court doesn't just step in for injustices. Like, if you have a criminal case and you're like, hey, I want this to go to the Supreme Court, you being innocent isn't enough for the Supreme Court to be like, we're going to intervene. It has to be that there's some sort of major, major thing going on with it, right? So, Supreme Court is tough to get into. They reject something like 80% of leave applications. They reject most leave applications. So they may say, you know what, we're not hearing it. And if they say we're not hearing it, that's the end of it. It's over, it's done. But if they decide to hear it, then I have a fuck ton more work to do, because I expect that there will be interveners. I expect that there will be, I'm going to have to do a lot of work, a lot of writing. It's going to be a major project. So anyway, every step that I take at the Supreme Court level costs a ton of money. It's just straight up. The leave application cost me $8,000. So just to get that filed and so forth, $8,000 to get that in the, get that in. And, prior things, $4,000. So yeah, that's the give, send, go. Hold off. If you want to throw money at it, okay, I'll have to figure that out. But if you don't want to at this point, that is perfectly reasonable. So, if you're wondering what's the case is basically that when they banned the AR-15, they sent out a letter nullifying every registration certificate. Now, nullification is a term that was never before heard by the court. It's not in the law. It's not in any prior case law. And so then when they were challenged on that, they changed their mind and they said that now it is expired, notwithstanding that there's no provision for that. So yeah. Did you choose Give, Send, Go because in part GoFundMe listens to our government and freezes funds? I chose Give, Send, Go because GoFundMe has a past history of removing fundraisers that they think are that they think are not like in their that they don't think are like in their political sphere. So they'll remove fundraisers for criminal defense. They'll remove fundraisers. And I'm pretty sure that if I sent it to GoFundMe, that if I set this up on GoFundMe, they'd be like, we are removing this because it is a fundraiser for, gun issues. So Give, Send, Go does the same kind of thing, but they don't care. They're completely politically agnostic, so they don't care one way or the other. So that's why I went with Give, Send, Go, because I know they're not going to nuke it just because. All right, so let's look at Irini Scordi-Bello really briefly. And I say really briefly. Kiana Bunch says, can we send it directly to you? Yes. Either via email money transfer or via PayPal. So Irini Scordi-Bello is interesting. And they have her on the stand basically the entire day. But we're going to cover her very, very briefly. And the reason why we're going to cover her very briefly is mostly because I am in tremendous pain. And also because at the end of it, Oh, somebody wants the link. Okay, I can do that. At the end of the day, what they get out of what they get out of her is not super momentous. What do they get out of this witness? Well, she is the Emmy. She signs the death certificate and she indicates the findings, which were undetermined. Undetermined. She's like, undetermined. Oh, yes. Yeah, let's talk about that. What do I think about the forensic specialist too? Let's go to that. That's at the end. That's a good thought.
Can you rephrase that question?
Could have
I want to correct
questions again.
All right.
Thank you for answering my question.
Your
All right,
Honor.
Ms. Hartnett, you are all set.
I wanted to correct something from the record yesterday. I wasn't sure when was appropriate to do that.
Okay. Do you recall which lawyer asked you the question?
Yes, Mr. Leslie asked me the question.
Your Honor, are we going to proceed along with that?
So why don't I see you at second?
Thank you.
He's like, Your Honor, I have some concerns. And she's like, yeah, I understand you have some concerns. I will see you. Oh, hello from Vancouver Island, Canada. I haven't been to Vancouver Island in a long time, but I totally want to. Okay. Now I see an important question. Is correcting something in court usual? No. Very unusual for a witness to be like, I've got something I want to correct. Now, Marmar, I thought I saw you in the chat. Are you here, Marmar? If you're here, pipe up. Because I might need your help. So here's the thing. Marmar, which where did we go for the first meetup in Vancouver? Because I'm thinking there again, because that was actually really awesome. So this is very unusual where they're like, we need another, like, I want to correct the record. Now, normally if you want to correct something, that's something you got to speak up for right away. She doesn't get to like just say she wants to talk about things just because she wants to talk about things, right? You don't get to just do that. So, and nodding affirmatively, if you were saving your money for important things, that's yeah. So, you don't normally just get to like correct the record. She's like, I said some things and they were wrong, and I really just want to.
All right, so Ms. Harnett, I am going to let you step down because questions from both sides are completed.
Okay,
so
thank you.
though.
So the judge is very polite, but she's making the correct ruling today. The judge is absolutely making the correct ruling here because the judge is like, you don't get to do this, right? You don't get to just do the thing. So I think this is the correct ruling. It's, I don't know what she was going to say. I'm guessing it would have been better for the Commonwealth than for the defense. But this is the correct, this is the right way to do it. All right, let's sort of jump in with Scorty Bello a little bit here. And I'm basically picking a point at random because Scorty Bello spends a lot of time talking about this. And there's a lot of issues there. Right? Also, before we do that, I'm going to roll this because there we go. EE, thank you for the 20 gifted memberships. Much appreciated. So StreamYard is causing me all sorts of trouble. So Dr. Rini Scorty Bello is basically here to testify as to cause of death, which she put as undetermined. And the Commonwealth is being like, isn't it the case that he died because of head trauma and, hypothermia? And she's like, I don't really want to get pinned down. I don't really want to get pinned down on everything, right? She's like, maybe. She gives a lot of testimony to the effect of like, it's possible. And basically at one point she literally says, anything is possible.
See, as you stated, it was conducted. I just want to do a little bit of a timeline on January 31st of 2022, correct?
Yes.
And we discussed that the body of Mr. O'Keefe was...
It's all good, Kylie. It's all good. Also, I've got to do this. Early in this is that's ridiculous. Get a heating pad super chat. You'll thank me later. On donations, if these are considered gifts, they should not be taxable in Canada, i.e. they're not payment for a service or work. They're considered gifts. I'll have to look into that actually as to what the tax implications are there. Vancouver meetup was at the craft beer market in Falls Creek last time, or at least that's what I had marked in my calendar. All right, then I'm going to make an announcement. If you are in the Vancouver area and if you are interested in a meetup, July 12th is, and I'm thinking we'll do it at the same place. The first place was nice. So, craft beer market in Falls Creek. I'm told this is the address. I'll have to look it up. I'll have to post a full announcement there. But so July 12th. If you can make it, then excellent. If you cannot, Marmar says July 12th is set now. I am setting it down as July 12th. I am setting that date down. We will do a meetup there. We'll hang out. I don't know if I'll have hot sauce to bring out, but I might manage to bring a bottle or two. And I'll be there. We'll hang out. We'll chat. We'll have some drinks. We'll have some hot wings. We'll have some some all of those things. So that is the plan. Ebisoft says bring some moose that's on your trail cam. It won't have been hunting season yet, so I won't have hunted anything. So, Ian, could you turn your volume up? Yes. What is it? You should bring your cool mom. I mean, I can ask her. I can ask her. Can Americans invade? Absolutely. Yep. I am told I need to set another goal. So other goal is just Runkle has a goal. That's going to be the goal. There we go. All right. So let's have a look here.
Presented to the Cape Cod location, correct?
Yes.
And you...
Nico, I'm going to have a Quebec meetup. I'll have a Quebec meetup in later this year or the next. So, yeah.
Also discussed that you brought
Yes.
Dr. Stonebridge to work with you on this matter, correct?
She didn't physically come to the office. The way Dr. Stonebridge was involved is at the time of autopsy when the brain was removed, having seen that there were injuries,
So after they remove the brain, you are qualified to be an accident reconstruction expert for the Canton Police. Yeah. Cries in India, no meetup for us. I might make it to India one day, but it might be a while off.
saved the brain in a special solution, and then the brain was transported to our facility in Boston. That's where Dr. Stonebridge examines the specimens. And after examining the brain, she issued a report.
Who asked Dr. Stonebridge to become involved in the matter?
I did.
And Dr. Stonebridge is triple board certified, correct?
Correct.
She's a forensic pathologist, correct?
Yes.
That means she's achieved board certification in forensic pathology like you?
Do you know that?
I do.
I love it.
Yes, she's
I like that. Do you know that? She's like, I do know that. Yes. I do know that. And the judge is like, okay, then she can answer the question.
board certified in forensic pathology.
And she is board certified in general pathology, correct?
Yes.
And she's board certified in neuropathology, correct?
Correct.
Can you briefly describe to the jury what neuropathology is?
He's got a very slow delivery that does that works great for that.
Pathology is a
You could come to Massachusetts for a meetup. The Waterfall has a nice private room. I feel like if I asked the Waterfall for a private room, they would lock the door from the outside and set it on fire. So that might not be a good idea.
subset or specific additional training in forensic pathology where the person spends a considerable amount of time, usually 1 to 2 years, examining brains and learning all about the diseases of the brain as well as trauma to the brain.
Now,
Brain study is difficult. Like when people say, like that person's no brain, like it's not brain surgery. Brains are tough because they are, they're dense and we don't understand them nearly as well as we would like. At the end of the day, brains are meat that does all sorts of shit that we just don't necessarily understand all that well. And we would like to, but yes. So, yeah. And yes, she clearly appreciates Dr. Stonebridge and thinks she's pretty awesome, which, she probably is. All right, let's jump a little bit ahead here.
The actual appearance of it.
what I'd like to do now is, Mr. Wolf, what has been in evidence, what I'd like to do is to, with your Honor's permission, publish some depictions of first the gastric mucosa.
So I just want to note here, Alessi is absolutely the guy to cross-examine the doctor because he's like, let me show you some pictures of the gastric mucosa. And he launches into this from a total medical perspective. He's like, I'm going to use the terms. And he does an excellent job on all of this, right? He does a fantastic job here. What is it? Why is she speaking about a brain being sent to another doctor? Because they took John O'Keefe's brain out and they mailed it out. So, yeah.
Then start with that, Your Honor, publish that.
All right. So this is the one that we have not introduced into evidence openly, but it's sidebar, right?
What I'd like to do is I'll start out with the one that is in evidence, which is the gastric mucosa.
Okay.
That's what I've heard as well. I have not, and I'm not sure where I'd get some. Yeah, I've heard he's a pharmacist, and yeah, histotechnician here. I'm not phased.
Okay, so that was the one I was referring to that we did at sidebar, not in open court. Okay.
I hope they didn't trust his brain to USPS. Still better than UPS.
All right. All I'll say about this, jurors, is that this may be considered graphic. You satisfied with that, Mr. Lessie?
I'm satisfied with that, Your Honor.
Okay, Mr. Brennan?
It's just they're like, jurors, we're about to see some stuff, and it's gonna be gross, right? And the good news is that for us here at home, we're not gonna see any of it. So yeah.
You satisfied with that?
Yes, Your Honor.
Okay.
And we're gonna play this. Shay B, thank you so much for the 50 gifted memberships. So thank you so much. What is it? Pick up your prescriptions in 1 hour, but if Alessi is working, you'll get them in 3 hours, but you'll also be very well informed about them. Fair. UPS can't find my house. They can find mine. They just demand money. So yeah. All right. Shay B says, let's go green. Thank you so much.
May I, Your Honor?
Yes.
Dr. Storabello, I'm handing you Exhibit 164 in evidence, and I'm going to also, with the court's permission, have it published on the screen. So whatever one is best for you to look at the screen, please feel free to look at either one. Mr. Wolk, if you could publish 164.
I don't know what his name is. Is it Woke? Like WOKE? WOLK?
Dr. Storabello, do you recognize 164 as the, well, you describe what 164 is.
This is a picture of the stomach of Mr. O'Keefe after it was removed and opened and the contents were removed. And what you're looking at, this pink red surface is the mucosa. That's the lining of the stomach. And you had used the word rouge before. These are the folds. The stomach has a lot of folds. And what you can see here are small areas that are redder than everything else. That's hemorrhage, that's blood. And these are the gastric hemorrhages that I described.
Right, so those are what you just showed. There's darker areas, there's just a few of them. That is what you refer to as hemorrhages, correct?
Wisniewski's was correct.
Well, you didn't use Wisniewski's in your report, correct? You referred to them as hemorrhages.
Correct.
Okay, so what I'd like to do now is to, if I may approach, Your Honor,
Yes.
for the chalk.
So here's the thing about the Wisniewski spots is that they are often associated with, hypothermia, right? They're often associated with, and that is, helps establish the Commonwealth theory. However, the defense gets her to acknowledge that he'd been taking like Pepsid, like literally just an over-the-counter antacid. And so they're like, so he drinks a lot and he takes antacids to deal with that. Isn't it possible he could get the same lesions from drinking? And she's like, yes, that is totally possible. Those lesions could just be from drinking and from the antacids and so forth. And that is pretty brutal. So I think that, that is one of those things where it's like, that is an excellent admission to get from the witness. And Brennan tries to save it on redirect. Let's see. Can we find Brennan?
Cooling, mechanical cooling, complete and
All right, so here we have Brennan trying to save things, and Brennan his thing is awful.
The case of this particular case, those hemorrhages, the context of a body found in the snow, I believe they were due to hypothermia.
is your answer more complete in context?
Objection, Your Honor.
Sustained.
Yep. All right, let's talk about this part.
You to complete question,
Yes.
and he read
So,
rather than just part of a statement.
Yes.
And when you were asked the question that counsel asked you, Do you remember that grand jury testimony you gave?
I remember it was a long time ago.
Okay.
But I do remember most of it.
Do you remember when he read part of your answer? It was in response to a grand juror's question.
Yes.
And he read part to you, right? I understand your question. And my answer is that I don't know, but given the environment, so if the injuries had been sustained in a different environment where the temperature wasn't that low, then there might have been an alternative explanation for those gastric and pancreatic hemorrhages. Do you remember that?
Objection, Your Honor.
He can't read. Like, basically the problem Brendan is having is that she testified to stuff in front of the grand jury, and Brennan likes the grand jury answer better than the answer she gave today in court. You can't do this. He's literally trying to introduce the prior consistent statement, which is one of the obvious examples of hearsay, right? Yeah. I don't get it. So
The doctor can answer that.
Do you remember Attorney Alisi read you that part of your statement?
Yes.
Do you remember that you had more to that statement that was left off when he confronted you with it?
I'm sure there's more to this.
To complete your statement, you said, but in the whole context, I believe that those are signs of hypothermia and not caused. Do you remember that completion to your statement?
Objection, Your Honor.
Sustained. You can show her the statement.
Okay. I can approach. Actually, take a look at part of the grand jury testimony. Do you remember Attorney Alisi reading part of your answer back?
Objection, Your Honor.
So I'll strike that. Have the witness look at it.
you can't introduce her prior statement just because she's not saying the stuff you want her to say today.
Will you ask about your entire answer or just part of it?
Objection, Your Honor.
Sustained.
Can you read the rest of the answer that you weren't given when it was read to you?
Objection, Your Honor.
So this is phrased as refreshing.
He's like, objection, objection, objection. And yeah.
Recollection, so follow it appropriately.
Do you now remember there was more to your answer?
Yes.
Could you share with us the rest of your answer?
Without
Objection,
reading
Your
it.
Honor.
Without reading it. Turn it over. Turn the paper over, please.
I can take it, Your Honor.
Ask the appropriate question.
It's an in-court statement, but it's not in this court. Hearsay isn't any court, it's this court. This court proceeding. They can't just tender, because he basically is just like, please testify the way you did before, and that's what I want to hear. You can't force that.
Mr. Brennan.
Do you remember the part that was left out?
Objection, Your Honor.
Sustained.
Does it refresh your memory to the rest of your statement to the grand jury?
I'm sorry, what was your question?
After looking at this, does it refresh your memory to the rest of your statement you made to the grand jury?
Yes.
And could you share the rest of your statement with the jury, please?
The rest of the statement was that I have to take those findings in the context which was presented to me. So in the case of this particular case, those hemorrhages, the context of a body found in the snow, I believe they were due to hypothermia.
Is your answer more complete in context?
Objection, Your Honor.
Sustained.
You were shown a photograph of two individuals that were in the room at the time of autopsy. Do you remember that photograph?
Yeah, I suspect
Yes, I
that
do.
And you were
lawyers
asked
are
about
going to...
certain names.
Correct.
You said that there would be a log identifying names.
Would be a log. Yes.
A log. Do you remember exactly who logged in to that autopsy?
No, I don't remember their names.
May I approach?
Show Mr. Lesson.
It's part of the end of the report. It's in there. Possibly take a look. Yeah.
Your Honor.
Brennan sounds more and more like a Muppet as he goes. I just feel like, and I don't mean that like just as a generic insult. I mean like literally a Jim Henson's Muppet voice. He would do well at. So
If you need sidebar to explain, we just need a moment to take a look.
I can move on and we'll come back to it, Your Honor.
Thank you, Mr. Brennan.
You mentioned that Mr. O'Keefe's body temperature was a little under 81 degrees when he was brought to the hospital.
Yes, that's what the hospital records stated.
And again, a normal body temperature is?
98 degrees.
So there was, is it fair to say there was over an 18-degree drop in his body temperature?
Correct.
I resemble that.
You shared with
comment.
us that you generally understood it was a blizzard and cold outside. Do you have any experience on how rapidly a body temperature will drop outside?
The body temperature?
Yes.
Objection, Your Honor, still.
No, it's within the scope. Let's see if she's got the basis for it.
The rate that the body loses heat depends on a number of factors. Depends on conditions, weather conditions. It depends on the original temperature of the body, and the higher the gradient between the body temperature and the environmental temperature, the faster the drop will occur.
You were asked if there's any signs of frostbite. There was no type of freezer burns or anything on Mr. O'Keefe's body, was there?
Objection, Your Honor.
Sustained.
Was there any type of burns on his body that would suggest that he was put in some type of machine or environment where there was cooling, mechanical cooling?
Objection.
What? What? Okay. This is bizarre.
Sustained. Sustained. Move on, Mr. Brennan.
You were shown a photograph, a chalk.
Where
that
does he
had
get
spots?
Where does he get freezer from? Like, he's like, was he freezer burned like the steak you forgot about? Like, what? Like, I've eaten a lot of freezer burned steak because I just forget about it in the freezer, and then you pull it out and you're just like, oh, that's not good. Pro tip, grind it up into a soup. But he's like, is he seriously asking if John O'Keefe got freezer burn? I'm like, where does this come from? Yeah.
On them. Do you know where that photograph came from?
I do not.
Do you know who that was from, what person that was from?
No, I do not know the context of that picture.
Do you have any information on the circumstances which led to that condition?
I do not.
Do you have any information about what caused the condition that you saw in that chart?
I have seen similar pictures in textbooks depicting gastric hemorrhages or Wisniewski spots.
You were asked about your role as a medical examiner, and there were a number of questions about your assessment from a legal.
All right, we're going to skip ahead a little bit.
Was communicated to us, yes.
Thank you.
All right, Mr. Lessie.
Thank you, Your Honor.
I don't know why they said freezer in this
Dr.
case.
Scorti-Bello, this Attorney Brennan just asked you questions about alcohol consumption. You had the opportunity to evaluate the medical records of Mr. O'Keefe, correct?
Correct.
And you had, in terms of the medical records, information with regard to the medications that Mr. O'Keefe had taken. Is that correct?
I believe I reviewed those records at some point prior to issuing my report, yes.
Do you recall the list of medications that were in the medical records that Mr. O'Keefe was on?
I do not recall.
If I were to show you a document, might that refresh your recollection as to the list of medications?
I'm going to allow it. Is in connection with alcohol too, you said, right?
Correct, Your
Go right
Honor.
ahead.
I love that. In connection with alcohol too, you said, and he's like, correct. You bet. That's exactly where I'm going.
That's correct.
Yes.
Dr. May I? Your Honor?
Yes.
Dr. Scorti-Bello, you may understand by the witness here.
Yes.
Dr. Scorti-Bello, I am providing you with a document. Up at the top it says John O'Keefe, and I would like to draw your attention to medications. And to expedite it, I am going to focus on the fourth item on that list. Can you state what that medication is?
The fourth item is omeprazole.
Does that refresh your recollection as to one of the medications Mr. O'Keefe was on?
Yes,
And that medication is,
it's an antacid.
right, and so omeprazole is the trade name of omeprazole Pepsid?
I believe so.
And Pepsid is a proton pump inhibitor.
Correct.
and a proton pump inhibitor stops the proton pump in the stomach from releasing acid, correct?
Yes.
And we're going to come back to that in just a moment, but do you also recall testifying at the grand jury with regard to alcohol consumption and potential alcohol consumption of Mr. O'Keefe?
I do remember testifying, yes.
And do you recall what your testimony was with regard to alcohol consumption and small ulcers in the stomach potentially associated with alcohol consumption?
Alcohol consumption, I don't recall my exact words at grand jury, but alcohol consumption can lead to gastric ulcers.
And alcohol consumption can lead to gastric ulcers. And what medications can treat gastric ulcers?
And the medical folks in the chat are going, it's Prilosec. So, yeah. Yeah.
Well, they don't treat them, they prevent them, but that would be a proton pump inhibitor such as omeprazole.
Right. So
if he had gastric ulcers, he might decide to, say, use those to, or treat those with a proton pump inhibitor. And that would be like exactly what we're looking at, right? So he's having some fun with this.
isn't it correct, therefore, that the ulcers that are observed in the stomach of Mr. O'Keefe that we talked about, the gastric mucosa, could have come from ulceration due to alcohol consumption,
It's possible.
as opposed to hypothermia, correct?
Correct.
She's like, oh, yep, that is an explanation. This is the wonderful thing about experts is that
Attorney Brennan asked you questions
yeah.
moments ago, and actually several of them, of which included the words, did I hit him? Could I hit him? Do you recall those questions?
I do.
And isn't it correct that you had that information before you issued your final findings in this matter in April of 2022?
Yes, I did.
So, even though you had all that information, you still were unable to conclude the manner of death of Mr. O'Keefe, correct?
Correct.
Thank you, Dr. Scordi-Bello.
Doctor,
He's like, thank you, Dr. Scordi-Bello. Yeah, he's finding her to be very helpful. All right, so what we're going to see next is some really interesting exchange here. And I'm going to have all sorts of thoughts about it.
all set.
Thank you, Your Honor.
I'm going to see counsel at the sidebar.
All right, let's skip past the sidebar.
Minutes early. I'm told that we are on schedule. So with that, I'm going to let you go a few minutes early. So please do not discuss this case with anyone. Don't do any independent research or investigation into this case. If you happen to see, hear, or read anything about this case, please disregard it and let us know, and be very careful with your social media use. So we'll see you tomorrow morning.
Rest of the jury.
Yes, that you can find the link. Oh, I think I bumped the link. So, but I am taking Extra Life donations. Yeah. I'm sitting on the O'Keefe side in court. I'm just here. They really should call it the sidebar.
Okay, be seated.
All right, so Mr. Lessie, I'll hear you. I'll hear you, Mr.
All right, we're going to take this down to 1 speed.
Lessie.
Thank you, Your Honor. The topic I would like to raise with Your Honor is the timing and nature and significance of the information that the defense has received from the firm Aperture. And Your Honor may recall there are two individuals on the witness list that we understand are to testify in this matter. First is Dr. Judson Welter, and the second is Shannon Burgess.
And are they testifying in reverse order, though, than what you said?
My understanding is, Your Honor, yes. That
Okay.
My understanding, Mr. Brennan has the best information, is that it's proposed that Mr. Burgess testifies first and Dr. Welcher.
I have not heard about his
Okay.
sidebar
So-
merch.
The Commonwealth has established in reports right up until May, not established, they had stated in the reports of Aperture, particularly the slide presentation of Dr. Welcher,
Is that somebody who thinks I'm wearing a wig?
trigger called 1162.2 that they had associated in the report of Dr. Welcher with a specific time. And that specific time that they have associated with that trigger is 12/31/38 to 12/31/43. And we have been assuming that information, and this is from best memory, but I believe it's slide 137 or so, where the statement is in the slide. And so we have proceeded with our defense. We have proceeded with the work that has been assigned to ARCA based upon that time period. On May 8th, not too long ago, Your Honor, we received an amended report of Shannon Burgess that pushes that time period. I'm just going to get it.
So May 8th is a week ago. What day was it this trial started? What day was it that this started? Vaughn, if you want to send something, first email me at runkleofthebailey@gmail.com and let me know what you'd be sending, because I gotta have more management over it.
So, although it was dated May 8th, we received it actually on May 11th.
So they got it May 11th, which is Sunday of this week. So they've had it for 4 days. Yeah. April 1st was jury selection. That took like a few weeks. So somewhere in the 20th range. Yeah.
And in that report, Mr. Burgess states that he is making an amendment, and he is now stating that that infotainment trigger of 1162.2 is further back in time, and it is past 12/31/43.
Do you have the time?
I'm going to get the exact time, Your Honor. It is 12/32/16. And Your Honor may recall that the seconds, literally seconds, matter in the analysis of many factors. I won't go into them other than to say I went through and developed testimony with regard to the cross-examination of Mr. Whiffen. He had a timeline. He talked about much human volitional conduct. Suffice it to say that that information is literally.
All right, let's talk about this, because this isn't just a situation where they're bringing in new evidence. They're bringing in new evidence midway through the trial. And not just midway through the trial, but midway through the trial and after the defense has already committed themselves to to their theory, right? And the thing is that the jury has already been seeing these different details, and the defense has been asking questions specifically to poke holes in the Commonwealth's theory. And so what the Commonwealth appears to be doing is to be saying, oh, well, the defense has been poking holes in our theory. We need to amend our theory in order to, in order to basically rule that out. And that is messed up. This is insanely prejudicial to the defense to say that the Commonwealth gets to change their theory midway through and have their experts redo things and decide, and their justification for it is going to be absolutely super thin. This is ridiculous levels of ambush.
By seconds determinative in some ways of various analyses. So we basically commissioned, if you will, ARCA to be looking at matters based upon the infotainment trigger 1162.2 of 12/31/38 to 12/31/43. As of May 11th, we received information that has changed that. Now, Your Honor, that is a Rule 14 violation, among other.
I feel like we could have a drinking game for Rule 14 violation in this trial. Ooh. So, yeah, they're like, why did they not disclose this? Why did they not do this until well after the deadlines? They have deadlines for reciprocal disclosure or discovery, so that they can't do this midway through the trial. Oof.
Issues, but I wanted to start there. It's a Rule 14 violation. It's obviously, as I stated, an amendment of a report of a significant matter. And also, with regard to the defense's ability to provide a defense, we have to be able to evaluate that information in terms of our entire defense. And it's just not limited to ARCA. It's our entire defense.
And this is the thing. They called evidence. They elicited evidence on cross-examination that was key to it. By the way, if you see me flinching, I attached a TENS unit because my back is really killing me. But if you see me sort of doing weird flinches, that's what that's about, because I've got it turned up way too high. Yeah.
The other data point I want to get to, so the effect it's had, we still haven't even been able to evaluate entirely that. And I believe, Your Honor, based upon the information that I have, that this may have been a calculated matter by the Commonwealth, but even assuming it's not calculated, the effect.
I mean, it's super, super calculated, right? Obviously, they're doing, they're sandbagging the defense. They're 100% sandbagging the defense. It's
is pronounced. So what I want to do, Your Honor, is to look at what the reason Mr. Burgess has given, which leads me to be very concerned about a calculation and a strategy calculation here. Mr. Burgess states in his own words that the reason why he is changed, that time is being changed, is to, quote, align the trigger with Mr. Whiffin's analysis. And
the thing is they're going to claim that it's Mr. Whiffin's analysis from his report, but I'm sure that it's Mr. Whiffin's analysis from his cross-examination.
Whiffin's analysis is based upon the extraction data from Mr. O'Keefe's phone. And I believe it's undisputed that the extraction from Mr. O'Keefe's phone occurred years ago. The data from that has been...
It was available at the first trial.
It's been available years ago. So to me, Your Honor, that basis can't be a proper basis at particularly this stage where we are approaching the end of the trial, just literally days before the testimony of Aperture. And we are in a very, very almost impossible, challenging situation. So, Your Honor.
And the thing is they can't backtrack their theory in front of the jury. If the defense has been calling evidence and eliciting evidence specifically toward, like they've been eliciting evidence from Commonwealth witnesses specifically towards undermining the theory as they had it. And so if the Commonwealth is allowed to change their theory, it makes the defense look like they were chasing some sort of shadow or bullshitting them. And this is unreal. Like, it's unbelievable that they're getting away with this.
There are obviously, Your Honor knows the situation here. Our first request is that the May 8th report that we received on May 11th be not allowed, that it be not considered at all. As Your Honor knows, I don't like to use hyperbolic words, but the word has been used for us, against us, ambush, ambush, ambush. If there's ever an example of an ambush, this is it. And so Your Honor.
And this is a much better example of an ambush because it's happening mid-trial. Mid-trial.
Honor, our request is that Your Honor find a Rule 14 violation, that Your Honor have the remedy be that the violation remedy be that this is not allowed, and that the Commonwealth proceed with its the information of Aperture that has been extant before the May 8th date of the report. Thank you.
All right. Do you have another option if that's not something that we do, right? Because the Commonwealth moved to exclude ACCA or have them go by their old report, right?
Right. And Your Honor, I'm going to answer.
And the thing is this isn't the same as ARCA because A, the Commonwealth doesn't have the same fair trial interest that the defense does. The defense always has a stronger interest in fair trial. But B, they didn't tender ARCA mid-trial, right? And yeah.
Answer your question, but with just a quick point that this is really much different than ARCA because two reasons. We are the defense, and
yes,
ARCA is a rebuttal to the prosecution's case. That is much different than a prosecution changing its theory of the case at this time.
I understand that. I'm just asking if you have another option.
It's not what I...
And I mean, the answer here is what else would you do, Judge? I mean, I have another option. I have a great other option. I think it's a fully reasonable option. Mistrial with prejudice. Do it.
am saying that I am proffering. I think the only remedy here is exclusion and a Rule 14 violation.
And you're not waiving that?
I'm not waiving that.
No, I'm not asking you to.
Your Honor.
Okay, a continuance for how long?
I could have a better answer perhaps to that question tomorrow. I haven't, given what's been going on, I haven't even had a chance to talk to ARCA at all.
All right, so tomorrow morning.
I don't think a continuance is a reasonable solution here. I don't think a continuance actually fixes the problem because the defense has committed to this in front of the jury. I don't think a continuance is at all, I actually think this was an error from Alessi, and I like Alessi, but I think it was an error for him to say continuance is a possible solution here. I don't think that a continuance is a
morning.
Is a good
Let me
one
know
there.
that. All right.
In Your Honor, I will do that, of course. And I will also say, without getting into...
A continuance is a delay. Like, so a continuance, they might put the trial over to next month. I don't know how they do a continuance when they've got a sitting jury, but, you know, yeah. So continuances, they give them, you know, they delay the trial for a bit and then they start it up again. So, yep.
An elaboration of it, we have to look at all the witnesses that we called. I'll give you an example. Mr. Whiffen, I had my whole cross-examination, not whole, but a significant part of my cross-examination of Mr. Whiffen based upon going through human volitional conduct off that phone that was after that 1162 trigger. And a lot of our defense in theory is based upon that's been in existence now for several months. And again, I go to the bottom line that the proffered reason in Mr. Burgess's report is to align with the data on Mr. O'Keefe's phone, and then that's been around for a long time. So that's my answer to Your Honor's question.
All right, thank you. Mr. Brennan.
Your Honor, this disclosure is not a Rule 14 violation.
Okay, this is going to be good. I'm like, okay. When it's coming in last minute after the deadline, okay.
The Commonwealth, just like the defense, is entitled, continues to work on their case and study their case.
What the fuck? You've had an entire trial. You are midway through another trial and you're like, we're entitled to try to figure out what the fuck is happening? If you're sitting here trying to figure out what's happening, still at this stage, there is an appropriate remedy. There is an appropriate thing to do. Drop the case. Like, oh my God. He's like, we're still trying to work it out. We're still trying to study it. I'm like, no, that is not how this is going.
Time goes on. This issue, the relevance of this issue, has been clear throughout the case, including my opening statement. And the issue is that clocks are different. There is a clock in a Lexus that runs on a different time than that of an iPhone. If you recall in my opening statement, I talked about the fact that there are variances between those.
I'm sorry, has the concept of clocks been new? Like, is this new evidence that you didn't know about clocks until just now, or you thought every clock ran at the same time? Like, Brennan, I know you're old enough, because I'm old enough, and I'm pretty sure, like, you know, to remember that a time before your clock was able to talk to the internet. And, like, you know, people having faster clocks or slower clocks. This is not new. This is, like, not news. This is something that you ought to have known about, or at least the possibility of, since, I don't know, like, you know, 1998? Like, come on. So, yeah, I don't get his argument here. I don't see it at all. Yeah.
Clocks. So instead of a moment that coincides happening at the precise second, sometimes there's a variance of time between the two. So the Lexus clock could be at a variance with an iPhone, but the event still could happen at the same time, given the clocks have different times. The defense provided a report by a person by the name of Mr. DeSorga, a noted expert witness who they've listed as a witness they may potentially call. Mr. DeSorga wrote a report, and in the report, he suggested, based on his analysis, that Mr. O'Keefe's phone always ran late. That means if the text stream data, the black box data from the car.
So this isn't new then. This is like, oh, you know, this is information you should have known forever ago.
As a event at 12:32:38, 12:31:38, and Mr. O'Keefe's last movements were 12:32:16, last user interaction 12:32:09, there is a variance between those times. We asked our expert to review their expert's report to see if he was accurate, that the variance means that these times would never align. And that's what he did. He studied the data, he studied the Waze, he studied the Lexus black box relative to the time. Doesn't change anything, doesn't change.
So I'm just wondering, because like the iPhone gets its time from like the universal time signals, right? I'm like, how is his phone that is getting like exact time sync all the time running slow? Like, is his phone like in some sort of other universe that runs slower? I don't get it. And like, yeah. I mean, does the defense get time to call an expert into like time and space? Yeah.
Into the data whatsoever, just adds to the time. What he learned from his opinion is that Mr. DeSorbo was wrong. He used information from different phones, not recognizing the items that these timelines came from, and that his time estimates are wrong.
So we've got a motion for pigeon business. Do we have a second for pigeon business?
And he looked at the time of the event of the ignition on and off, and he compared that to the Waze data. And when he did, he found that he could identify what the actual differential was. Instead of guessing that it was within the 30-second window, it was somewhere around 21 to 25 seconds. And that.
Oh, so instead of guessing, he's got it down to 21 to 25 seconds. And we've got a second for pigeon business, so... Motion granted. Motion carries.
7 minutes before the collision, Mr. O'Keefe's phone was 21 to 29 seconds ahead, which means you subtract that time, which puts it in the same variance that we've been arguing from the beginning, that the collision occurred at the same moment when Mr. O'Keefe last had user
Gotta think about this.
And that reconciles with the data. It does not change the text screen data or the black box information on the car whatsoever. It does not change ARCA's analysis whatsoever. We received this report.
Except that it does change the fact that they were attacking this hole, that you're like, oh, well, now we're going to change our theory. Villanova, I got to think about this. If I were the defense, I wouldn't call Proctor to use the adverse inference. So jury, you can infer from the fact that they didn't call Proctor that, I mean, I don't know if Bev would give, or Judge Cannone would give an adverse inference instruction on that, but and then argue the Bowden defense thing only in closing. You don't gain anything else from Proctor being on the stand. You might if Proctor really, really embarrasses himself. Proctor also has some text messages that you would need him to get in if you wanted to get them in. And some of those are things where he's like, using the C word. I don't know. I think I would call him, but you're right that there is some risk to it. And I can't say that your strategy, like I can't reject it out of hand. Certainly. I certainly cannot. So no, that I have to think about it, but Matthew Self says the state should have their theory solid prior to bringing a case. I agree. If they want to bring new info to the table, it's a mistrial. The state should compensate the defense for bringing an ill set of facts. State has the burden and unlimited resources. At this point, if it's a mistrial, it should be a mistrial with prejudice. And that should be the end of it. It should be, sorry. Proctor's the only way to get in. He's a Boston cop too. Yeah, that is a big one. That is a big one. So, yeah.
On May 8th, I was surprised to receive it. I welcomed it. We turned it over on May 8th. There was no delay. It's been a week now. The defense has had this information. And so this is not an attempt to align anything. While it may reconcile or identify that variance more closely, it doesn't change any data whatsoever. And so this is not a Rule 14 violation. The effort was in response to disclosures that we believe were wrong by the defense expert, and it is clarified and it is favorable for us. And so we should be able to use it.
Did you intend to use it in your case in chief, or only if this witness disorder? I don't remember reading that name, so I don't know how to pronounce it.
My case in chief, because we now have this available data. As I said, this wasn't ambush, isn't something that we sat on. It was in response. Fortunately, we received their expert report, which caused us to focus more closely. And now that we've identified that variance, rather than having an open variance of 30 seconds, we should not be precluded from favorable information that has been provoked by a report by the defense.
Okay.
He's like, we only have this because the defense. I'm like, yeah, this is mid-trial. Mid-trial.
Yes.
I'll do it quickly.
Okay.
Attorney Brennan has provided a lot of information, and he has accurately provided information, but he's got the time completely wrong and the significance respectfully completely wrong. I'm going to hit his 4 categories quickly. He said he referenced Mr. DeSorbo, who is a defense witness. Two points about Mr. DeSorbo. First, Mr. DeSorbo provided his expert report within the reciprocal discovery deadline.
Okay.
And he provided that report months ago.
Okay.
So if, as I heard Attorney Brennan, he's saying the reason why we're getting something on May 8th is because Mr. Burgess supposedly is responding to that. That was months ago.
Okay.
The more apt point is, or an even more apt point is, Mr. DeSorbo was responding to the information of Aperture. It wasn't like Mr. DeSorbo was coming up. He was rebutting as defendants do. So, and it's Mr. DeSogra, D-I-S-O-G-R-A. Again, D-I-S-O-G-R-A.
I like how he spells it out and the closed captioning still gets it wrong. D-I-S-O-G, they drop the R-A.
So that's an important point with regard to Mr. DeSogra. Now I want to go to Attorney Brennan's comment about clocks are different. I agree with Attorney Brennan on that. The shortcoming for Attorney Brennan's argument, however, is that the clocks are different concept has been in existence in this case for over 6 months.
And this is also, like, didn't they call evidence on the different clocks in the first trial? But I mean, it isn't over 6 months that the concept of clocks being different has been an issue. That's been an issue since literally clocks, right? Literally since clocks existed, they have known that clocks can be different from each other. Like, if you're wondering why, like, old cities have clock towers where they've got bells that ring at, like, noon and so forth. Well, first of all, back then, a lot of people didn't have clocks. But second, the bells ringing at noon allowed you to align your clock to the city clock, the main. So, like, literally back to the era of, like, London Tower and shit like that, we've known about this as a problem. So, yeah.
I can give you by memory Mr. Whiffin's report of December of 2024, where his report went into the different clocks and what their significance was. So that is almost 6 months ago, at least 5 months ago, the issue of different clocks has been in existence in this case. So therefore, the issue of different clocks dates back to then. But even more fatal for the Commonwealth's argument is that Mr. Burgess himself issued his report and talked about the difference in clocks. He already knew it. He already had it.
Did he testify to that last time? Did he testify?
Aperture was not part of the first
All
trial.
right, I thought Burgess was, no?
No, neither.
Okay.
No one from Aperture was.
I knew
Your Honor.
Aperture was, and I thought he may have been something. The name just sounded
Neither
familiar.
Burgess nor Welcher were
Okay.
part of the first trial, but they were retained. Aperture was retained, I believe, in October of 2024.
Okay.
And at best for the Commonwealth, Aperture had, and Mr. Burgess and Dr. Welcher had Mr. Whiffin's report that talked about the clock differences. So the clock differences cannot be, as the Commonwealth is proffering, some sort of new information that caused Aperture to.
So let's talk about how courts tend to view information and the timing of it. So one of the issues that will often come up is the issue of fresh evidence. And so one of the questions for fresh evidence is this actually fresh evidence? And the principles here generalize. So, a fresh evidence application is, let's say Bob gets convicted of killing Fred. Not this Bob on screen, hypothetical Bob. So he gets convicted of killing Fred. And then after the trial, he's like, I found a video that shows me not killing Fred during the time when Fred was getting killed. So he wants to have a new trial so that he can tender this new evidence of, him not killing Fred. Now, the court will examine this in the context of fresh evidence. They'll say, you don't just get a do-over. You need to not just, have this can't just be stuff that is, new as in you didn't present it at the last trial. And it can't even just be stuff that's new as in new to you. It has to either be genuinely new, like it didn't exist at the time, but that seems difficult, or something that through ordinary due diligence you couldn't have uncovered or produced, right? So that's sort of the key thing here. Here he's saying, sure, you didn't know this, maybe, but you ought to have known it, and therefore you're presumed to know it. So, yeah.
Provide a new report. This variance that Attorney Brennan talked about, it's called the clock drift. A more layperson's term is a variance of time. Mr. Burgess.
I like that. So did you see? I gotta criticize Alessi slightly for this because it's funny.
That Attorney Brennan talked about. It's called the clock drift. A more layperson's term is a variance of time.
He's like, it's called clock drift. A more layperson's version is a variance of time. And I'm like, that is not more layperson. That is less layperson. I feel like the layperson is more likely to say clock drift than they would say variance. So, yeah.
Mr. Burgess, in his original report months ago, has a whole section on clock drift. That's not a new concept for him.
I feel like Alessi hangs out with different laypersons than the average bear. I feel like he's probably not yeah.
He's just changing the drift.
Okay. So what I'd like to do, because I want to address the other issue and I don't want to keep people here too long. Can you wrap it up, Mr. Alessi, or is that?
In 60 seconds.
Okay.
Thank you.
All right. We're going to start our timer. They are at 7 hours, 17:17.
Your Honor. Your Honor, the last point I wanted to make, and I think I heard Attorney Brennan correctly, is he said he was surprised that he got this report dated May 8th. That's what I heard. So if the Commonwealth is surprised that they got it, that should mean, to me, Your Honor, be an outstanding, fetching reason to not allow it because they're surprised to get it. And I can lastly say this, Your Honor, there's nobody that's more surprised to getting this than the defendant when we got it on May 11th.
Okay, thank you.
Boom, under 60 seconds. When he says, I need a minute, he does it in a minute. And I just want to say how unusual that is for lawyers. When lawyers say they're going to do it in a minute, they're going to do it in like 30 minutes. Now, yeah, I'm not going to make the joke that just came to mind. So we're just going to keep moving.
The other issue about calling your expert on rebuttal, Mr. Brennan, based on the late disclosure of the ACCA materials. What's your argument on that?
I won't iterate the entire past, but Your Honor has found discovery violations. Your Honor has found that I want to phrase this properly, efforts of the defense were improper. And inevitably, we've now received an extraordinary amount of discovery on the most important issue in this case, well beyond the discovery deadlines, without.
Oh, look, you already have a ruling on that. The ruling, as I recall, cited the case of get the fucked. So, yeah.
Any excuse. And the court, understandably, has overruled government's objection and has.
Oh, I have a thing for this. Where is my thing? Where? He's complaining about how the court has overruled his objection. I need the. No, it fell. Where is it? I gotta dig for it. Oh, things are falling. Chaos is reigning. All right, here we go. I have a thing for this. Here we go.
On the most important issue in this case, well beyond the discovery deadlines, without any excuse. And the court, understandably, has overruled government's objection and has stated that it's going to allow the defense to proffer two expert witnesses in a very complicated field. In an issue that is the heart of this case. We're going to allow them to testify, despite the fact that we have not had the time to review, to prepare, and to address it. The Commonwealth has the burden of proof. The Commonwealth has an obligation to prove this case beyond a reasonable doubt. And this isn't simply late disclosure of some evidence. This is a massive amount of evidence of the most critical issue. And so we provided this information to Dr. Wexler. As you know, he was away. He did not get a report until maybe May 7th. He did not have a chance to look at it until May 9th. An extraordinary amount of work, effort, and expense has gone into preparing our case for the jury. He is still in the process of reviewing the materials. There are entirely new subject areas within this information, well beyond the simple four opinions that they gave at the beginning. There are studies, there are demonstrations, there are experiments. This requires not only review,
so what is it you want?
Testing, vetting, and then preparing testimony to address the claims.
What do you
made
want?
by the defense experts.
As a lawyer, you should always lead off all of this stuff with what you want. This is a basic advocacy thing. If you're going in court, you start off with what do you want? You know, so like it's, Your Honor, I want you to grant me a cheeseburger. And the reason why is because, and then you go through the reasons. You don't make the judge figure out what it is you're asking for and then later get to cheeseburger, later. For a couple of reasons. One, You don't want the judge to come to their own conclusion first as to what you deserve, because they might decide you should have, like, steak or pie or a brick. But the other thing is that it helps frame the argument. It's like, is there actually a remedy you want, or are you just, whatever? Is it Canadian courts have the power to bestow cheeseburgers? Not really. But like, let's say I'm arguing for bail. I'm going to start off by saying, Your Honor, my position is that my client should be released on bail and on the following terms, and I'll list the terms, right? So, yeah.
Not to get into a battle of disparagement, but our expert.
Not to get into a battle of disparagement, but it's like, oh, that's where you live, Brennan. Let's not pretend you don't like it. So, yeah.
Has found extraordinary issues in his first reviews of material. And some of those concerns lead him to need, in his opinion, to actually conduct his own tests to demonstrate the failures of these ARPA witnesses. That's going to take time. You've heard from the ARPA witnesses themselves. With the amount of data they received, they estimated they needed 5 weeks. And they were given 5 weeks despite all the discovery deadline violations. They were given 5 weeks. We did not get the report until May 7th. And so we believe we are entitled to have our expert review all the materials, do his testing, provide opinions. None of that is going to happen anytime soon because he still has not.
So what do you want?
Reviewing all the materials. There's many, many gigabytes.
What do you want, Hanky? Do you need a hanky? Like, what is it you actually want?
He's in a difficult schedule. He is away tomorrow, Saturday. We were going to try to begin to prep at the end of the weekend. There is no way he's going to be able to testify anytime soon and have all of this validation and vetting and testing.
So what is it exactly you're proposing?
So what would you like?
Finally, she's like, so what do you want? Like, this is what you should have led with, Brennan. EE, thank you for the 20 gifted memberships. It's much appreciated. Okay, so what does he want? What's he asking for?
What to do is have him testify about what he has prepared, that he's had adequate time to prepare. If either of these ARPA witnesses testify and they introduce new opinions, new testing, new demonstrations, he should be able to continue reviewing the materials, actively engage his own testing now, so by the time the defense case is over, he will be prepared to come back and address the new issues, not the older issues.
Are they asking for a second, okay?
Or regurgitate his testimony, but to address any new issues that were provided in violation of discovery orders, and so that he can then address the jury on those specific new issues. I see.
So he wants to split his case?
No other way of this expert fairly being provided and presented to the jury. The unfair prejudice cannot be cured in any other way. We ask that he be able to continue his review, offer rebuttal opinions on anything that is new, and not to encroach on anything that's been previously provided.
Can Burgess testify after Welcher?
No, because Dr. Welcher relies on Shannon Burgess' information material. It will make no sense. I thought about it. It makes no sense to the jury, his presentation, unless Shannon Burgess has an opportunity to provide the background information.
Right. Mr. Lessie, I'll hear you on this.
Thank you, Your Honor. I think and I understand that it's very well understand the time of the day, so I'm going to do this hopefully efficiently. When we're talking about,
He's like, everyone wants to go home. Okay, gotcha.
ARPA and the information of ARPA, it's very important analytically to put them in their two proper buckets. The first bucket is the information and opinions.
I mean, I've got a bucket to throw Brennan in.
Of ARCA that have been in existence since February of 2024.
Yeah, let's focus on the beyond. Let's focus on.
Okay, good, because my pithy conclusion is there should be no prejudice on that.
And I don't think the Commonwealth's even suggesting that.
So if we're focusing just on the quote new information bucket, Your Honor, it's very important to understand that what ARCA is doing is in response to the testing of aperture. ARCA did not come up with new approaches. We, again, to state the obvious, are the defense. We get to rebut what the prosecution has put forward.
And the thing is, the prosecution shouldn't be figuring this out. The prosecution is basically saying, we want to get all of the benefits that normally go to the defense, and, you know, but those should go to the prosecution because, you know, fuck fair trials. We want to get on a hanging here. So, yeah.
And so what ARCA has done with the new information, new testing, is simply to rebut what Aperture has done. So I do not understand the length of time or the lift, if you will, that's being proffered for Aperture. Now with regard to the time period, Your Honor has already determined what the appropriate approach is for the new information from ARCA. You
already ruled on this, Judge. Don't re-rule on it. You solved this. This is a solved problem.
Dr. Rentschler was on stand, and with Dr. What you said, when can you get me the information? And they said, I think it was May 6th or May 7th, whatever, and they met the deadline. They did it. We proceeded along with the trial with that information. We complied with that request to continually try to claim that there should be ongoing remedies of something that's already been decided. I do not understand.
So I did leave open. I did leave it open to address.
You did leave open the time, but Your Honor didn't leave open that you were going to.
I didn't delete your comment. If anybody deleted your comment, it would have been YouTube. I don't know what the comment was, but if you repost something, I'll read it out. I don't know what the comment was, so.
Continue to address this matter as if the defense is making perpetual violations. There was a determination made, and then the question was the remedy. So I'm just addressing the Commonwealth, positing that somehow there's continuing violations. My final 2 points. What Mr. Brennan is seeking is improper. What it's seeking is the most extraordinary situation, which is have Aperture come before the jury, testify to certain things, have ARCA have to come on, and then have Aperture come back and essentially have almost a rebuttal to a rebuttal as of right. I do not understand that process. I do not understand that proposal.
And Brennan was literally the guy who was saying there's no sure rebuttals. So I don't get it. I don't get it. Grifting Gamer, I found your comment. Cop here. I don't like Karen Reed as a person. She's every cop's toxic ex embodied, but she's obviously been framed by Massachusetts State Police. Every cop with a pulse knows it. So we found your comment. And yes, I kind of agree with you here on this one. You're not the first police officer to reach out and be like, so this looks really awful to me. So yeah.
It inverts the order of proof. It prejudices the defendant because it almost ipso facto gives a double rebuttal, surrebuttal to the defense. I believe,
To the prosecution
Your Honor,
is what he meant.
the final point is, if Your Honor is inclined to give Aperture more time, and I haven't even heard a deadline yet for Dr. Welcher. It's still open. What I would recommend, Your Honor, is that we follow the proper order of proof. We determine when Aperture can conclude its review of the ARCA work, and that there be a reflection that keeps the order, namely that the prosecution comes in with Aperture, Dr. Welcher, and Mr. Burgess, and then the defense, as part of its case in chief, puts on ARCA, and we make the determination as to what happens there. Otherwise, what we're happening is here, it's almost a self-serving matter where the Commonwealth is getting to put on certain witnesses here from our witnesses and then have an automatic rebuttal. And Your Honor, I just think that's improper and prejudicial. There's another, and importantly, it's a burden shifting to the defense.
All right, so I have a question for you, Mr. Lessie. Are you still thinking that if the defense puts on a defense, that will take roughly a week and a half for that to take place?
That is our best estimate still, Your Honor.
And
Week
not
and a half,
holding you
okay.
to this, because obviously you have no burden. If ARCA is part of that defense, when in that week and a half time frame would that be?
We haven't made a final decision, Your Honor, but we're pretty close that it would be toward the end.
Okay. All right. I needed all this information now, so I appreciate it. All right. Thank you.
Court, all rise.
All right, let's watch this on. Yeah, we're on one speed.
Thank you.
Brennan is not having a good day. Brennan, watch him with the laptop.
All this information now, so I appreciate it. All right. Thank you.
Court, all rise.
He's like, peace out. I see somebody saying again.
All right. Thank you.
Court, all rise.
So I don't know what she's gonna do. People are like, what's she gonna do? I don't know. I know what she ought to do, but what she ought to do and what she should do are very different things. Now, I saw the thing, if the defense puts on a defense. That's not her throwing shade. That's not her being a jerk. The reason why she's saying the if the defense puts on a defense is that the defense is not required to put on a defense. The defense is not, like, at the end of it, they could theoretically decide, I don't think they will, but they could theoretically decide that, when the Commonwealth closes its case, they could theoretically say, we're not calling any evidence. We're over. We're done. We're good. And I can tell you, most trials, that is the amount of evidence that the defense calls. Most trials, the defense doesn't call evidence. But in this case, I expect that they will. So I heard it as if they call ARCA, because she says, if you call ARCA, when are you calling them? And she says, I'm not putting you, I'm not making you pin yourself down on this. So, I mean, at the end of all of this, I look at it and I go, this is messed up. This is messed up. So, I don't know. I hope she doesn't give the Commonwealth the ability to split their case, because that's bizarre. And it kind of inverts the typical order of things, which is based on the fact that the prosecution has the burden of proof. But the prosecution shouldn't get to go first and also get to go last. That doesn't make any sense to me. But we're also going to see what she does with respect to this, this new clock aspect. And that I am highly concerned about, because like the defense is getting sandbagged, and the Commonwealth basically let them commit to a defense, and then is like, now the Commonwealth can change their mind. So I am just wondering. Now, people are like, are they going to appeal? Well, I mean, there's lots of stuff to appeal. I hope they don't appeal this, because I hope that the reason why they're not appealing is because they won. But we will see. I don't know how this ends up going, right? This is, but I think that if she allows these shenanigans, that this is appealable, this is going to end up being like the world's longest appeal, because there's just so many issues. And it's a really weird proceeding. So as I mentioned, a friend of mine is getting called to the bench. She's becoming a judge. And I was like, I need to be there to help celebrate this, because yeah, absolutely. So I was like, well, we can talk about the medical examiner later. Like, the medical examiner is not that big of a, thing at the end of the day. It's kind of they fight over it for the better part of the day, but I don't think it's gonna be a huge thing. And then I saw this shit. Then I saw this, whatever the fuck we gonna call that. And I was like, I have to talk about this, because I'm mad. I am mad. So, this is beyond bizarre. I can tell you that if a Crown prosecutor tried to bring new evidence to midway through a trial like this here, I would expect that the result would be that they would just, they would toss it. This is insane. So, Nicholas Starro says, tell us how you really feel. I think I did. Good to see you, Nick. Yeah, I am baffled. This case, it feels like a zombie case, because this is a case that really ought to have been dead by now. You watch a horror movie and you see the villain get shot full of holes, and it's like, all right, villain's dead. And then it just keeps coming back, and it keeps coming back, and it can't die no matter what happens. And yeah, I am stunned that this case is what it is. It is so bizarre. And it's bizarre to the point where it's hard to talk to people about it who are in my regular life. Because, if I go up to regular Crown prosecutor and they're like, so what are you covering? Because, and I'm like, well, I'm covering the Karen Reid trial. And they're like, I haven't been following that one. What's that about? And I'm like, well, and I explain it, and they're like, that doesn't sound right. That doesn't sound, true. And I'm like, but it is, though. And they're yeah, you're just, something's, and, no, this is 100%, if they're just like, no, that would have been dismissed. Somebody would have thrown that out, wouldn't they? And I'm like, nope. This case does not die, will not die. And I am astounded by it. So, yeah, I just don't really know what to say other than this is such a bizarre case. So, I got a bunch of super chats to get through, and we're going to read through those. I'm wondering if the cheese shop on Granville Island was still there. I'm, what is it? Also planning for the trip to Vancouver because, yeah, I'm. All right, so let's have the thing there. Fancy RPG. I'll make a plan to come to Vancouver with my 4-year-old. The craft beer market is amazing. Please don't make it start too late at night. I'm thinking I will start it at like 6. I'm thinking I'll start it at like 6 and go late. So we'll start early and just keep at it until people are tired and want to go home and so forth. But I can show up there and either 6 or maybe 7. Maybe 7, because I don't know if I want to eat at the craft beer market now that I think about it. So maybe I'll go to the area, have some food, and then go in full of food so I can, drink and then proceed from there. So, I got to figure out the timing exactly, but yeah. All right. Let's see. Scrolling up to the top here. Lady Draconis, thank you for the 10 gifted memberships. Much appreciated. I've got hiccups now, and my leg is twitching because I attached the 10s there. Pamela Wissenbach for the bath bombs. That's my next plan. Scott Roach, bath bombs for the win. Debbie W., the odometer question from yesterday is important. The key cycles are listed by odometer reading. Oh, that's a fair point. We haven't gotten to key cycles yet. Nancy Druby for the sore back to buy some bath bombs. And bath bombs, for some reason, is in quotation marks. So I'm not sure what that's about, but yeah. Joy W, back pain should just F off. Oh, that would be nice. That would be nice. Laura Christine, thank you so much. Ben Peenig, I hope. I'm not sure how to pronounce it. Everyone, please don't forget to support Runkle's Give Send Go campaign. Yes, we've got stuff going on there. So thank you so much. Is that Mexican pesos, I think, or Mexican dollars? I'm not sure how that. I don't know. I'm going to stop talking because I'm just embarrassing myself. Giselle Duke, my mom, dad, and father-in-law all had epidurals for sciatic pain. Maybe you should ask your doctor about it for yourself. I maybe should. I got to figure out what all this is about. Marto, Brennan needs some time in the freezer. Thilo Agthe, 50% pro bono fund, 50% Stollery. Not a bad thought. I'll have to ask the community, and that's an if, because if I get leave, the 40,000 maybe not enough, not too much. Marmar says, you're finally using the bath bomb. Sorry, I'm late. Yes. Mountain Princess. Hi, friends. Hello. Feral Dragon. Do you think Brennan hates his clients some days? Father-in-law fire chief in Brockton. In the past, they would anchor weighted tarps to fire trucks over scenes during blizzards. That actually makes a whole lot of sense. Michigan Farm Boy. Regarding correcting prior testimony, if you perjured yourself, does asking to correct it help, or are you screwed? I think you'd be like, if you were trying to correct the record and they wouldn't let you, that would probably be a defense. If not allowed to correct the record, I realize basically no one gets charged, especially if it helps the Commonwealth. I also don't think she would have been charged with perjury. I don't think that whatever error she made is likely to be perjury. I think it's likely to just be error. Jet J, Runkle Goal. My oldest just graduated university in Daytona Beach. Woohoo! Congratulations. That is awesome. Obiter Dictum. I can't help but think of Young Frankenstein, Marty Feldman, and Abby Normal. Apocalypse DOA. Point in fact, the Hope Diamond has been sent USPS. Can you buy enough insurance for the Hope Diamond? Greg says, I'm calling it now. At some point, we're going to get an Elaine-level train wreck on one of Brennan's redirects in this trial. Maybe worse. I don't think we're going to see Elaine again. Like, that was something else. The KKF 1015, maybe he just wants to hint to the jury that her answers are different, not consistent, and her testimony is sus because of that. Maybe. Chloe S., according to Google, lidocaine might be called Prilocaine or EMLA patches in Canada. I'll have to look it up. Obiter Dictum, we're going to have to pick a pack of Proctor photos to perform a proof of police personage. Diane G. OMG, just one more. Don't be poor and help the goal. Thank you. Opener Dictum says, nice to see witness who isn't threatened on stand. Yeah. Marmar says, this one's for the goal. Thank you. Brit Happens, you've hit your goal. Please, can we understand the end of day proffers about the Reconstructionists? That's what we saw. It's a whole thing. Gray Space, where's your intentional Rule 14 violation now? I mean, he's decided that's going to be how he rolls. Byron Butterfield, brains. Crimsoneer, I figured out why I had an instant dislike of Brennan. He sounds like Binger from the Rittenhouse trial, and I can't unhear it. I don't think he's that. No. Now I'm going to have to listen to Rittenhouse again, and I'm... Greg, sadly, I don't think there's a world where Bev makes the right ruling here. She's going to side with Brennan because she's already dug in on Arca. We'll have to see. I maintain some hope. Amanda Lang, have you seen Universal Ostrich Farm versus the Canadian Farm Inspection Agency? Yes, I have. That is the case where they are basically, they got an avian flu outbreak on their ostrich farm. And so the government's policy is that the ostriches have to be killed. They have to be culled. And the ostrich farm is like, please don't. Ostriches are not like chickens. And the government's like, yeah, they're close enough, though. And so I haven't read the actual decision yet. I mean to, but I kind of... I don't know. The internet is all like Team Ostrich, and I'm kind of like, I don't know. Maybe it might not be unreasonable. Greg, if she allows this new opinion, will they move for mistrial? We'll see. I suspect I don't know. Jessica Miller, the option is a dismissal with prejudice. Kind of, yeah. Rosebud 26, Bev is trying to find her way out via Alessi. It's a messed up situation. Good Kimmy, thank you for the membership. Matthew Self, honestly, the fact the state is trying to change its theory mid-trial outside of all good reason that may be appropriate, this is clearly the state screaming, my theory isn't working. I need more ammo. They're like, we've made a mistake. Please fix it for us. Just because call in the Time Variance Authority. I get that reference. Michigan Farm Boy makes me think of the saying, a man with one clock knows the time, a man with two is never sure. Digital and satellite time apparently doesn't fix the problem. Fair. I got to know, isn't time measured from accurate satellites? I mean, my phone updates the time constantly, so it's just always on sort of the same time as everyone else's phone. Andrew Fidel, for Runkle to go get a massage from a massage therapist tomorrow. I have an appointment booked for Saturday. So H Scorpio, cellular needs precise and accurate time to work. Yep, and what we don't know, the time sync in an iPhone can be turned off. Settings, date, time. When off, the clock shown can drift, which is also likely used by most logs. Okay. Yellow Pill NP, I think the defense may be better not calling Proctor not needed. Last trial he wasn't fired, so they had to convince the jury he shouldn't have been, or should have been. Have they actually managed to get that he was fired into evidence yet? Morgan says that is some A+ Alessi shade to Brennan there. Yes. Gray Space, don't be too hard on Hank Runkle. He just learned about clocks last week. Beach Rando, Runkle watch Hank slam down the laptop. We did watch that. It was funny. Beach Rando, so I'm not late to work. I suffer from clock drift. Gwynny Bly, HB, issue at heart of this case. Exactly. Denied? We'll see. Bob Alessi's vocabulary. Thank you so much for the super chat there, or the super sticker. And I feel like his vocabulary needs more space. Stacy Labruno, for the absolute brilliance of pulling out that tiny violin during Brennan's whiny speech. Oh my God, what a total pain in the ass this man is. He is something. Law Kong Express, the state is not entitled to a fair trial. I tend to think that the fair trial stuff needs to be more for the defense. So, Judge Kim Jong Kanoe, is this even legal, or do the Commonwealth, or for the Commonwealth to do a sure rebuttal? It's a very unusual state of affairs, to put it very simply. So, yeah, Raketsu, thank you for the membership. I see member for 24 months. Congratulations. Amanda Lang, are we sure we aren't living in Black Mirror right now? I am not sure of anything. So, yeah. Kurt Eaton, I wish we had the judge from the Turtle Boy hearings. I feel like that would be nice. That judge didn't seem to be full of BS. Grifting Gamer, this case is a CIA experiment gone wrong. Lol, thanks. I don't know what's going on with this case, but it's so weird. So weird. Runkle's colleagues be like, cute story, bud. Pretty much. I feel like I may have damaged my credibility telling people what's going on with this one. So, yeah. Marmar says, I think Alessi said laborious, not layperson. I was driving and couldn't chat till now. I thought it was layperson, but now I'm like, I don't know what's going on. So, and I got to roll this again. I say got to. I get to. EE, thank you with the 20 gifted memberships. Much appreciated. Chuck Morris, $200 will get you a good inversion table. Will change your life. I should look into that. Runs with scissors. Proctor, not Proctor at the autopsy. I don't know if they got to that. That was interesting. So, So yeah. What is it? Emily Hart. What makes me mad as I try to guide traffic? They say can't get home. Ma'am, if you go 100 feet, you'll be home. Happens every day. Please figure out your neighborhood. Fair. Jennifer, did you see Becky Hill got arrested for perjury? I did. And that's insane, but I'm going to totally cover the hell out of that. So, yeah. Shantae's Inferno. It's 89 seconds to midnight. We're all doomed. Talking about the doomsday clock. Amanda Lang, would love it if you'd cover the ostrich case. Impacts farmers near me. Active blockades at the farm right now. Very interested in your legal analysis. I guess I'll have to look at that. Michelle, the defense entered the picture of an arm labeled dog bite. I missed that. I may have to go back and look. So, and Light Queen, thank you for 10 gifted memberships. Much appreciated. And yeah. So tomorrow, Rob is doing is doing the Friday Night Frenzy. I will probably be popping in on that. And what is it? We'll check that out. I don't know if I'll do a recap. I also have to figure out. So Monday is a holiday here in Canada. It is Victoria Day. Whereas in the US, I think it's Veterans Day, like a week from Monday. So what that means is I will probably I might be camping on Monday evening. So I may not be able to stream. I'll have to see. I might be driving. Memorial Day. I might be driving back from camping at the land. I bought a camper. It's old. The camper is like from 1998, but it seems to be in good shape. It's like a fifth wheel trailer. So, hopefully that is like a little place for me to stay on the land as like a, whatever, but, yeah, we'll see. So, anyway, the long and short of this is I will stream when I can stream. And, yeah. This decision is real short. It's like one page. Okay. I could probably do a video on that fairly soon. Yes, Facebook Marketplace. Yeah. Oh my God, 1998 is so old. I feel ancient. Yeah, I got it off of Facebook Marketplace. I actually managed to find somebody on Facebook Marketplace who was like surprisingly awesome to deal with. And because they were awesome to deal with, I was like, I am just, I'm just gonna go for I'm not gonna fight them on what is it on the price on this one. It is just absolutely just let's go for it. So sorry, I said 1998. I was wrong. It is 1996 that this fifth wheel is from. So we're that's also there's like I want to get a wood stove put in it, but I have to get a really small wood stove for it, and the wood stove that I like for it is way more money than I can actually spend because it's a $4,000 wood stove, so that's not happening anytime soon. So yeah, we're just gonna figure that out in future. All right. Can I haul that with my Honda? No. No. No, I can't. Put in a new mattress in it. That is a plan for sure. So yep. All right. I see we got a few more. Check out a TENS unit for pain too. I've been using a TENS unit on the stream. It also has been hurting me, but hopefully it's going to help. So I do have a little TENS unit. Byron Butterfield says, I feel that Hank thinks he's a defense attorney. I do kind of feel like that's where he's at. And Bubbles says, thank you for helping keep me sane during this trial. Have a pre-med background. I can't with this case. So upsetting. You're not wrong. Oh, I got this thing going and it's like, oh. So yeah, that's today. And then we will go forward and see what happens soon. So, all right. Thank you all for joining me, and I'm gonna go soak with a bath bomb. So, thank you guys. Cheers.